Thank you so much, Volker. I think you already presented the paper. Let's move directly to the Q&A. Okay, I'll do so. I'll give a brief presentation. So the main point of the paper, as Volker just said, are these. What we did was to ask 123 retired judges in Israel to sentence defendants in two cases. All the judges received, of course, exactly the same material, the same vignette. The vignette included all the needed material about the cases, so the judges could easily make a decision about what the sentence is, like they do in a real court. And the result was that the sentences were very different from one another. Then we gave the exact same material to different LLMs using different prompting systems, and the results were first much more consistent. So sentencing was much more consistent between LLMs and within the LLMs, the different LLMs, and much more accurate, which is even more important. Now, how do I define accuracy in this case? I'll say something about it later on. And what is the conclusion? That the LLM can at least assist in increasing consistency and accuracy in judicial decision making. So that's the presentation from start to end, and now let's do it in a bit more elaborated way. So a bit about the background about sentencing. 1933, a very famous paper in the United States was published, Law Without Order, about sentencing law, basically saying that sentencing disparity undermines the principle of equal treatment, that each judge in the United States can sentence based on whim, and there is no real law in sentencing law. The sentences, at least in the US, also in Israel, used to be there's the maximum sentence, sometimes also a minimum sentence. In Germany, it's more common to have minimum sentence. In other countries, it's less common, but still very wide discretion. And in this discretion, the sentences varied dramatically. And after this paper was published, several studies examined the question and found that it is absolutely true. So the studies that were conducted back then in the 70s, gave judges, sitting judges, acting judges in the federal system, in the state system in the United States, cases and asked them what will be the appropriate sentence, and the sentences were very, very different from one another. The distribution was very, very loud. So what to do with that? In the United States, these findings, together with other findings about biases against minorities and with dissatisfaction with sentencing law from tough law and order groups, so all these findings together led the American to adopt a Sentencing Reform Act in the federal system, which included a sentencing commission, and the sentencing commission issue guidelines, issue rules exactly how to write a sentence. The rules were very, very elaborated in the federal system. So you had a very large and thick book which help you decide what is the severity of the offense. Which offense is it that the defendant was guilty of? How did he do it? Did he have a partner? How serious was the harm? And so on and so forth. Many, many questions. And with the book, you can find the severity of the offense in a numerical way. And then the same goes for the criminal record of the offender. Also, the judge has instructions how to find it in a numerical way. And then you have a table, a big table of offense severity, criminal record. If offense severity is 30, criminal record is 20 points, then you look at the right cell in the middle and find a very, very narrow sentencing range in this cell, and therefore sentencing cannot deviate substantially from one another if the cases and the facts are similar. So what did that, now states in the United States and also other legal systems in the world, including later the UK and many other, some systems in Australia, adopted much more lenient versions of sentencing guidelines. So not very strict like the American one, but one much more lenient, but the aim was the same, to reduce sentence disparity and to give some kind of equal sentences. What did it do? Well, studies show that the American federal sentencing guidelines did reduce disparity. Mission accomplished, to some extent. Maybe not to the extent people imagine. There were many ways to bypass the sentencing guidelines, but still it had some effect. On the other hand, it had many drawbacks, including reducing judicial discretion, so judges were obliged to give a specific sentence even if they thought that it is clearly unfair. Sometimes it was much, much harsher than what they thought the correct sentence should be, taking into account factors that the sentencing guidelines did not really give too much weight to. It empowered prosecutors because prosecutors can determine the facts. So prosecutor write the indictment and decide whether to indict the defendant with armed robbery or just robbery or maybe just theft, and not to mention the fact that the defendant had a gun or another weapon. So prosecutor could manipulate the sentence through fact bargaining, and that's why change the result. And of course, that also undermined consistency in sentencing. And it often resulted in much harsher sentence. The reason for that is that when you have a sentencing commission sitting in abstract, not in real case with real people, usually the sentences are much harsher than they are when you face a specific person with all the specific facts of the case. So the drawbacks definitely, in my view, in many others people's view, were more substantial than the advantages. And in 2005, the Supreme Court canceled the rule that obliged judges to follow the sentencing guidelines and made it advisory only, which in turn increased sentence disparity, of course. So it goes one way or the other. What about LLMs? Can LLMs help us reduce disparity? So in some systems, LLMs are already used in court. For example, in some Chinese court, LLMs help judges generate reasoning, but not yet help them write the decision. And there are more and more studies about LLM's accuracy. One noticeable one is of Eric Posner and a colleague that evaluate the accuracy of predicting outcome of the European Court of Human Rights. So in this study, they analyzed, they gave the LLM the facts that the European Court of Human Rights got, and so how similar is decision of the LLM to the decision of the judges. However, you cannot, with this kind of settings, decide whether the LLMs are more accurate than judges, because if it's similar, okay, so they are as accurate. If it's not similar, who is right? There is no answer to that question, and therefore there is no real answer to the question whether LLMs are accurate. There are many other studies about LLMs and judges examining whether LLMs are more formal than judges or more discretionary, and questions like that, but accuracy is something of a phantom. To the best of our knowledge, there is no prior research directly comparing LLM with human judges' decisions on the same case, and that's the important fact. I mean, there are studies, even I did a study like that, comparing LLMs to judges, but not to a case where many judges got exactly the same case, and it's obvious why that didn't happen, because it's very hard to get many judges to answer exactly the same factual case. So what did we do? We employed two fictional cases. Case one was a violent offense, case two was a sex offense. Both cases were guilty plea cases. So in Israel, like in most common law countries, you can agree about the facts and the offenses between the prosecution and defense, and then there's no trial. So all the facts are given to the judge as agreed facts, and the judge just needs to convict based on the agreement and then set the sentencing. So we used plea bargain, first of all, because this is the most common case in Israel and also in other common law countries. And secondly, because it helps us avoid the argument that maybe judges saw the testimonies and reacted to something that happened in court. Nothing happened in court. It was a plea agreement, and the judges in our experiment saw exactly what a real judge would have seen in real life in court. So we gave them the two cases. The first case, the defendant seriously injured another man during a drunken fight. Prosecution asked for 4 years, stressing how serious was the injury. Defense asked for 1 year, pointing to a defendant's personal situation in this specific case. I won't get into the details of the case. You can read them all in the article because that's not extremely important. The second case was a sex offense, a date rape case. And again, the prosecutor and the defense explained why the sentence should be different. As I said, there was a plea bargain, but the plea bargain or the charge bargain was only about the charges and fact, not about the sentence. And that, again, is very, very common in common law countries. So we have 123 answers to the two cases in years of imprisonment. That is what you can see in the bottom of this slide. And we now did the same with three, at the time, top LLM. Of course, the problem is that LLM improve all the time. But we took ChatGPT, Gemini, Claude, and each of them, with each of those LLM, we used three different prompting strategies. So as I said, we used GPT-4o, we used Gemini 2 Flash, and we used Claude 3.5 Sonnet. And in the zero-shot prompting, we simply told the LLM, these are the cases in front of you, determine the appropriate sentence, and we did not give any additional information. We did make it clear that we wanted to imitate the judge, so not to determine what he thinks is a good question, but what the court, what a court should decide as the appropriate sentence. That was in the zero-shot prompt. In the chain of thought prompt, we asked the LLM also to do it step by step and to explain the stages of the reasoning. And in the few shots prompting, each LLM was provided with three similar cases. When I say similar, I'm talking three violent offense cases and three sexual offense cases. They're not similar, of course, exactly, but we try to give cases which are very lenient, with very lenient sentences and very severe ones, to give them some background. I must add also that both parties in our vignette gave the court information about two cases. Each party gave the court two real cases, which they say, each party said these are similar cases, and therefore try to use these cases in order to convince the court whether to give a harsher or more lenient sentence. And therefore the court already had 4 real examples of cases, and in this prompting strategy, the LLM had another 3 examples. Now, judges were not given the same thing, but judges might know cases. To ensure consistency, we ran each model 30 times with the same prompt strategy using low temperature, 0. We also, in the paper, you could see also use a regular normal temperature setting, and with the API to make sure that the LLM do not learn and use it for the next. What were the results? So this is the result of the violent offense. You can see the judges in gray. You can see the distribution runs from half a year to 4 years. The distribution is very wide. And when you look at the LLMs, some LLMs, like for example, Claude Zero Shot, gave exactly the same sentence for the whole 30 times we ran it. Some did not, but the range ran from 1.5 years in the by ChatGPT Zero Shot. You had like 5 cases when this was the sentence, to 3 or 3.5. But usually LLMs gave between 2 and 2.5 years of imprisonment. You can see the same result here in this table. So we examine the distribution. As you can see, sometimes the standard deviation of the LLM was 0. In some cases, it was higher. In no case, it was as high as the human judge's standard deviation, which you can see in the bottom line. Same goes for the sex offense. Very wide disparity. We even had one judge giving a sentence which is harsher than the one the prosecution asked for, which is rare but possible. 1 out of 123. So it makes sense that there will be one case like that. And again, the LLM, although the distribution was a bit wider, still was clearly closer to one another. And you can see here, judges' standard deviation was more than 1, and the LLM standard deviation was usually lower, with one exception of a Gemini chain of thought, which had a similar, slightly lower, but a similar standard deviation to the one of judges. So, okay, we show that the LLMs are more consistent, which is important. We want core to be consistent, but that's not good enough, because I can create a machine that every question that I give this machine will answer with the number 5, okay? And this machine will be very consistent. However, it won't be a very good way to sentence people with this machine just because it's consistent. We also want the machine to be accurate. The problem is that what is accuracy? How do we know what is the accurate sentence when there is no external accurate sentence? So what we did was that we said, let's assume in favor of the judges that the accurate sentence is the average sentence that the judges gave. If the average sentence the judges gave is the accurate sentence, and if LLMs will be more accurate than judges given that fact, then they will definitely be more accurate with any other number we'll choose in the world, because you minimize the standard deviation by examining in comparison to your own average, or the distribution average. And therefore, if we prove it under this condition, under this assumption, we can prove it with any other number we choose. So we use the function which I didn't know before, but my co-authors did, MAD, which does sort of a standard deviation, but not to the average of the distribution, but to a specific number you impose on the function, and the specific number was, of course, the average of the judges. So the MAD of the judges is the standard deviation of the judges, the same thing, because you use the same number, but the MAD of the LLM is different. And what you can see here, for case 1, in all cases, the MAD of the all LLMs was much lower than the one of judges. In the second case, it wasn't always like that. We had 2 cases like Gemini chain of thought and Claude few shots that were similar to judges, but all others were more accurate than judges. Altogether, if you take, of course, all LLMs, all prompting strategies, all 9 times 30 observations we had with LLMs, they are much more accurate than the judges, meaning they are closer to the judges' average than the judges themselves. So, in conclusion, LLMs demonstrate significantly higher consistency in sentencing compared to human judges, as evident by the lower variance, but they also align more closely with the average of judicial sentence of individual judges, suggesting they could serve as an effective tool to reduce unwarranted disparities. Of course, this examination was done with sentencing, and now it should be we should try it also with other forms of judicial decisions. However, sentencing to some extent is the most problematic one because it's so unguided and so discretionary. So it's very interesting to check sentencing as a starting point. And this is all. Thank you.